Well, thank you first and foremost for everyone who's joining in today. I know a lot of folks are taking time out of their lunch break, and this may not be the most exciting way to spend your lunch listening to a brief little e-discovery webinar, but I do appreciate it. And our goal today, as Melissa pointed out, was just to briefly touch on some of the content that's going to be discussed more thoroughly at the seminar, and just give you a little sneak preview. And before we get into that, like Melissa said, I do practice labor and employment, so primarily I'm handling these issues from the defense perspective and the defendant side. But really, at the outset, it's critical to note that these issues, e-discovery, preservation, everything that encompasses, these impact both parties alike. Plaintiffs have discovery obligations, defendants have discovery obligations, they have preservation obligations, and so forth. So there's really a wide-ranging impact for what we're going to talk about today, beginning with the preservation, and I can't stress it enough how that impacts both parties. Everyone has an increased digital footprint now, from the smallest solo plaintiff to the biggest corporation, and these duties apply to all those individuals. But leading into the first slide, the reason why we're here and the reason why we need to take time to learn about litigation holds and our discovery requirements and obligations is really because there's a lot at risk if we fail to preserve documents properly, if we fail to abide by these obligations. I prefer to lead with the carrot sometimes, but in this case we need to really look at the stick and see that by failing to properly preserve documents, there is a wide range of sanctions. These sanctions actually come from a Duke Law article. It's called E-Discovery Violations by the Numbers. Some of you may have seen it. It came out in 2010. And it reads like a horror story. It shows a very exhaustive catalog of all the e-discovery sanctions motions that were filed, and the authors went through and cataloged them and identified all the sanctions that were issued and identified the percentage at which the courts were granting these sanctions motions. And they found sanctions were awarded for over 50% of the motions for sanctions that were that the parties moved for. So from these sanctions motions, you see there's a wide range of sanctions, starting with evidence preclusion and going all the way down to dismissal. So there is a potential that if you don't properly preserve documents, if you have other discovery violations, your suit could be dismissed and never heard for its merits, and that the entire suit can go away simply based on discovery disputes. So that's the importance of preserving documents, and that's why today we're just going to touch on the parties' requirements to preserve, when that preservation duty is triggered, and how to do it. So moving to the next slide here, I think the first question you have to ask yourself is, when is preservation triggered? Now, certainly this may vary if you're in state court. Some states have adopted slightly modified standards, but there is a generally accepted federal standard based on a party's reasonable anticipation of litigation. And certainly I'm citing here to New York district courts, but I assure you the Zubulake decision from the Southern District of New York is an oft-cited decision, and that the generally accepted standard is this reasonable anticipation of litigation. That means if you as a party reasonably anticipate litigation, you have a duty to start preserving documents, even privileged documents, because you don't know whether they will be produced or ultimately become a part of the lawsuit. But once you have this reasonable anticipation of litigation, you must start preserving. If not, the risk is you may lose documents, and again, that's what gets us towards sanctions spoliation. And what's critical, of course, to us as attorneys and counsel is that the duty runs to us first. As you can see there in the second quote, we are the advisors to the clients that let them know when they need to preserve their documents, their information. Now, this should be a collaborative approach. You should hopefully be working with your clients in advance to identify potential trigger points, so when they arise, you can assess whether a hold should be issued. But this is a responsibility of counsel to work with their clients. Those attorneys, we have to tell our clients about their duty to preserve documents. And again, if we don't properly preserve, we risk very serious sanctions, and we risk a case that all of a sudden becomes sidetracked and we're mired in discovery disputes, and we're too busy arguing about discovery to ever get to the merits of the case. So when we look at this general federal standard, the word reasonable should be raising red flags, because reasonable can mean so much to so many people and can be susceptible to abuse and, of course, confusion as to when a reasonable anticipation begins. And if we just go to the next slide here, I just want to reiterate, of course, once you have that reasonable anticipation of litigation, you must begin preserving your documents. And this applies to all litigation. This isn't just the the large mega lawsuits when Apple and Samsung decide to sue each other, every lawsuit has this requirement because you're responsible for the evidence that your party may have. So you need to be mindful of whether it's a bankruptcy suit, an IP suit, a family lawsuit, there are preservation obligations under the discovery rules. Now, of course, the duty to preserve and when it was actually triggered is not always an issue that the court has to address and identify. It's only when the other party has made it an issue, contesting it, alleging that you were derelict in preserving documents, you waited too long and documents were destroyed, or you didn't preserve enough documents. But generally it comes about when another party is saying you failed to preserve your documents, leading to spoliation, and now we don't have documents to prove our claim. And so the key for any attorney dealing with their clients and the key for any party is determining when the reasonable anticipation of litigation is triggered and then proceeding from there to issue a litigation hold or work with your party to preserve the documents. Now, at the CLE presentation, we'll get into a lot more detail about how courts have construed the reasonable anticipation of litigation. And I actually have an article I discussed where we've cataloged over 100 judicial decisions where different trigger points have been identified. But the one takeaway that I was hoping everyone would get today is that receiving a complaint, although oftentimes will be when you first learn of a lawsuit, it's not the only time. And if you simply wait until you receive a complaint, assuming you're a defendant, if you simply wait until you receive a complaint to start preserving documents, it might be too late. Out of the cases we reviewed, I have cataloged in an article I will present at the CLE over 100 decisions identifying trigger points that occurred well before the filing of the complaint, meaning the court told one of the parties, you should have preserved your documents at this point. You should have anticipated litigation. And these events range from the filing of an EEOC charge for folks doing labor and employment, knowledge that a product was defective, maybe a particular consumer complaint, a fatal car crash, a fatal helicopter crash. So there's a lot of events prior to the filing of the complaint that can trigger this duty to preserve documents. And if you're not looking for it and if you're not dealing with it with your clients, you may be missing out your preservation requirements and ultimately losing documents, whether they're lost through a normal retention plan, whether they're lost through other means. You have to be vigilant in what you're searching for and make sure you know when litigation is anticipated and when the preservation duty is triggered. Now, once the preservation duty has been triggered and you have to start keeping your documents, or your information, I should say, more broadly, what most organizations do is they then issue a litigation hold. They prepare the litigation hold and then distribute it to their employees because obviously they need to convey this message. And if we can go to the next slide, Melissa. Just a few things to think about when preparing a litigation hold, and again, we'll certainly get in this in more detail at the CLE. There's no set checklist for what should or should not be in a litigation hold for every situation. It is very situational. It will vary some, but there are some good practices to keep in mind and things to be mindful of when issuing litigation holds and conveying to employees or agents or whomever their duty to preserve these documents. Because ultimately, assuming you have a corporate client, they will be responsible for what their employees do. If their employees destroy documents, they'll be responsible. If their employees decide to have an Enron-style shred party and shred documents, they'll be responsible. So you need to make sure the employees become aware of their obligations. That's why litigation holds have come about, and that's their main purpose, is essentially notifying your agents, your employees. I do list the Sedona conference up here. That's another avenue to get a lot of information and examples of litigation holds that have been issued. So that's just another resource that I identified. But the third point there is one that I just briefly touched on, is that you cannot begin to preserve and issue a litigation hold unless you and the client have worked out a way to identify potential threats of litigation from their employees and then convey these concerns to counsel, whether it's the general counsel at the client or whether it's external counsel. So it needs to be an approach that begins with the client being able to identify these threats. If a manager terminates an employee and the employee says, I'm going to sue you, I'm going to file my charge tomorrow, that may be sufficient to trigger your preservation duty. The complaint may be a year away, but preservation could be triggered at that moment. There needs to be a channel in place that would allow that reporting to go to in-house, if there's external counsel, to then discuss with external counsel and quickly identify whether a litigation hold needs to be issued and documents need to be preserved. So that's why having these early discussions is so key, as to making sure you're not losing documents, you're not losing information, because the last thing you want to do is stand in front of a judge and explain to them why you waited so long to issue a legal hold and why you've now destroyed so many emails in the process, so many documents, etc. And just to provide a quick background on that, the reason I keep using emails as an example is I assume most of you know and most of you employ your practices. Most of our emails, and I'm sure most folks, their clients' emails have retention schedules and deletion schedules, meaning at a certain point those documents, those emails are going to be deleted, and if you're not telling them to issue a hold and stop that deletion for certain documents, you will lose relevant emails, relevant documents. And although there is a safe harbor for these retention and deletion plans, it only applies if you've properly preserved documents. So you can't go to a court a year later and say, we waited to preserve, and by the time we finally issued that litigation hold, well, gee willikers, we destroyed about 500 relevant emails from the time that employee was terminated. Sorry. That's going to be a huge problem. So that's why I keep saying email as an example. It's a very common one that's set to a deletion schedule. Sometimes it's as short as 90 days. So this is why there's such an urgency with identifying these risks, identifying potential trigger points for that duty to preserve. So at the CLE, we'll certainly get into more of the specifics about what to include in litigation holds, what best practices for the letters, how to convey this responsibility to your employees, how to convey it to your agents, and how to make sure that you are putting together a letter that will hopefully withstand scrutiny from the court, because the whole mindset of what you should be doing during this preservation requirement is documenting what you did and be prepared to present this to opposing counsel if you have to justify your actions, or a worst case scenario, to the court and explain why you chose the methods you did, why you either failed to preserve documents or elected not to preserve them, or whatever it may have been. And the last slide here that I just wanted to touch on today is once the litigation has begun, there's other ways to then start managing and limiting your discovery. The goal of the presentation is to obviously discuss preservation requirements, litigation holds, and that initial management of preservation, but to also consider certain ways to minimize those costs in discovery. The problem with discovery for a lot of clients is it's a David and Goliath battle. Again, referring to my experience in labor employment, if we terminate one employee and a client has a lawsuit based on a single employee, we've got one employee, or former employee, who has only a finite amount of information and potentially a national corporation. At that point, you can see there's quite an asymmetry between the amount of documents and information one party has. So there's ways to start managing what information needs to be preserved, collected, produced, and there's many ways to start considering that and preempt these issues to hopefully minimize your costs, minimize your potential for sanctions, and reduce certainly the resources expended just in the discovery phase. And a few points that are just mentioned here. When you go into your Rule 26, assuming you're in federal court, when you go into your Rule 26 conference or any conference before discovery begins, discuss with your client in advance, get an idea of what type of information they have, the universe of potential documents, the time ranges, the key custodians, all these critical pieces of information so you can be more prepared to discuss with opposing counsel what you think will be relevant and hopefully get a better definition to the lawsuit. I'm certainly not the only one, I'm sure, who's seen a very vague complaint and had no clue how far back do we need to go, who was involved in this, who was implicated. So if you get that information prepared, you can have a more meaningful Rule 26F conference. And I know a lot of individual states certainly have similar pre-litigation, or I should say pre-discovery conferences. A lot of complex business divisions have these conferences as well. And if you're in a state or a situation where you don't have a mandatory conference, there's nothing that prevents you from picking up the phone and speaking with opposing counsel and getting a better idea the parameters of the discovery and the parameters of their claim. Next, using the Rule 26F conference you can start picking out these issues that you're going to have, start trying to maybe stipulate to the extent of their claim, how far back does it go. Another consideration is a clawback agreement, which is a great way to protect parties, and we don't really have enough time to get into that now, but it's a way to make sure that if there is inadvertent production, a clawback agreement is a great way to go ahead and give yourself a little extra protection. And lastly, before I turn it over to Mike, evaluate cost shifting. Ultimately, discovery is a very expensive endeavor. E-discovery has made it more expensive because, as I was saying at the beginning, our digital footprint has only expanded, increasing the cost of preservation, collection, review, and production. Anything we can do to limit that saves the client's money, and there are decisions and rules which allow for cost shifting in scenarios. It's not the easiest thing to get, but there are possibilities for even shifting costs in discovery if they're becoming so onerous that it should be the other party's burden to bear. So these are all some considerations of ways to hopefully kind of limit and manage e-discovery. And then ultimately, if you have these discussions, hopefully at the beginning of the lawsuit or in the beginning of the discovery phase, it can then help you as you advance into the collection and the review.